What's going on, everybody? Soliaka here, and I will be at the UF Levin Law School building on October 18th. That's going to be this coming Wednesday. Links will be in the description below. If you want to come see and meet and greet, and it's going to be me speaking, and then there's going to be a Q&A after. If you have the time and you want to come out, please come out. And right after that, we're also going to be going to the Ben Shapiro event. That's going to be on the outside. We're just going to be hanging out and seeing what's going on the outside of this Ben Shapiro. But let's get into this video. Now, if you don't know, or you just joining this channel, I had a lawsuit. I was suing Officer Kunkis. If you don't know that, I'm going to be playing clips throughout this whole thing, so just be ready. But let's start with the first clip, and just so that you get the context of what's going on.
Oh, what?
For real?
Yeah, yeah.
You're not carrying that around.
I was going fishing, man.
With this?
Whoa.
Is it loaded?
Hey, hold on.
Is it
I
loaded?
do not.
Huh?
My Fourth Amendment right.
Yeah.
Hold on. I don't consent. I don't consent to any of this, man. I'm going fishing. Look up 790.25 Section 3 Subsection H.
Who'd you vote for?
It's not about who I voted for, man. While I'm engaged in fishing, hunting, and camping, I'm allowed to do this. Look up.
Don't you think you're going to get people really excited about
I'm not worried
carrying
about what.
weapons around?
Hey, look. Right now, I am telling you what I am doing is lawful.
Yeah, but right now you're not coming for fishing because there's no fishing this year.
It's going to and returning from, sir.
Yeah, but
Going to and returning
So
from.
where were you fishing from?
I was going fishing
Going where? Which
to the inlet.
There's no inlet over here.
It's over there.
You can't fish over there. It's been
I
closed.
can't fish where the people are fishing right now on the inlet.
On the other side, maybe. Not on our side.
Well, guess what? I'm turning around and I'm going to go back to fishing
How
because
did you get here?
I walked.
From where?
Doesn't matter.
Yeah. I'm
No,
asking
it
you where
doesn't
you
matter.
live.
If I can walk to and from fishing, hunting, and camping.
Okay, that's true. All right.
Okay, if you're saying there's no fishing on that part of that inlet where I saw people fishing on this side of the inlet, so I walked.
You caused a complaint, so you're
No,
scaring people.
it's not a.
Yes, you did. How else would I know you were there?
Look, I'm not. Turn around, that's fine. Okay. I'm not.
Now, I started this lawsuit back, I believe, like February of 2022, somewhere around there. And it was going through some things. I had a deposition. Do you know what 790.053 is?
No,
Do you know what 790.06 is?
no,
Under 379.354 of the Florida statutes. Do you know what that is?
no,
Do you know fishing regulations in the state of Florida?
a few of them.
What are those regulations you know?
Size of snooks.
What are the regulations for snook?
The snook has to be between 14 and 29 inches or some approximate size like that. I'd have to refer to the book.
If I was to tell you it was 28 inch, or on the east coast of Florida, it's 28 to 32 inches, and on the west coast, it's 28 to 33 inches. Would you agree or disagree with that?
I would say that sounds reasonable.
Well, that's 100% true.
All right.
The definition of an expedition is a journey or excursion undertaken for a specific purpose. My question was, as a reasonable person, would definition 1, section A journey or excursion undertaken for a specific purpose.
Was the purpose
As a
political
reasonable person,
demonstration?
would that be a reasonable definition of what I was doing?
Well, there's your ostensible purpose, then there's your actual purpose.
Well, what was my actual purpose?
Lawsuit.
Was I carrying my firearm lawfully in the state of Florida?
Yes. Although you refuse to assist me in determining that with surety.
Once again, I come back to the Fourth Amendment in 901-151. Do you believe I have civil rights?
Yes, you have civil rights.
Do you believe you violated my civil rights?
No, I don't agree.
There's a lot of things I'm gonna be playing through this. So anyway, we're gonna get into those. But I was suing this gentleman or this, whatever you want to call him, whatever. And throughout the process that I was going through, I had violated, I believe it was Rule 60B. And it's basically what it was is in a timely manner. I thought I'd filed something, I didn't file that, and then I had to refile it. And then I went on to the appellate court, and that's where this is starting. I was in the appeals process and going through that, and this is what they had to say about this incident. So, just so you know, I'm going to be basically reading straight from this. Michael Taylor versus Andrew Kunkis. And then it says, Michael Taylor's appeal, the district court grants of summary judgment in his 42 U.S. Code 1983 action against a police officer. He argues that the officer, Andrew Kunkis, lacked arguable reasonable suspicion to detain Mr. Taylor and arguable probable cause to arrest him. Taylor also argues that the district court abused its discretion and denied in the Rule 68B motion for relief from the judgment. And like I said, this isn't going off so much the merits of the case. It's not saying, there's no merit to this. This was a rule that I'd missed, and there was something that I didn't send off in a timely manner. That's what this is. That's what that's referencing. So we've got part one. We review a district court's grant of summary judgment de novo, viewing all the evidence and drawing a reasonable inference in favor of the plaintiff. Fish versus Brown, you can look that up. Summary judgment is appropriate if the movement shows that there is no genuine dispute as to the material fact and the movement move on entitled to judgment as a matter of law. A brief investigatory stop does not violate the Fourth Amendment when the officer has reasonable articulable suspicion that a person has committed or is about to commit a crime. Arrests must be based on probable cause. Probable cause exists when the facts and circumstance within the officer's knowledge would cause a prudent person to believe, under the circumstances shown, that the suspect has committed, is committing, or is about to commit an offense.
How did you get here?
I walked.
From where?
Does it matter?
Yeah. I'm
No,
asking
it
you where
doesn't
you
matter.
live.
If I can walk to and from fishing, hunting, and camping.
Okay, that's true.
Qualified immunity shields government officials performing discretionary functions from liability for civil damages in 1983 actions, so long as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. In the context of an allegedly unconstitutional arrest of an officer is entitled to qualified immunity if, based on the totality of circumstances, the officer had arguable probable cause to make the arrest. Arguable probable cause is a lower standard than actual probable cause, and only requires that under all the facts and circumstances an officer reasonably could, not necessarily would have believed that that probable cause was present. Likewise, when an officer asserts qualified immunity in the context of an allegedly unconstitutional investigatory stop, the issues is not whether reasonable suspicion existed in fact, but whether the officer had arguable reasonable suspicion to support an investigatory stop.
What? Yeah. I was going fishing, man. Whoa.
Is it loaded?
Hey, hold on.
Is it
I
loaded?
do not.
Huh?
My Fourth Amendment rights.
Yeah.
Look up 790.25, Section 3, Subsection H. If I can walk to and from fishing, hunting, and camping.
Okay, that's true. All right.
Okay.
Arguable. I even told him.
If I can walk to and from fishing, hunting, and camping.
Okay, that's true. All right.
Okay.
But anyway, in the case of Officer Kunkus, moved for summary judgment and supported same with a statement of material facts, Taylor filed a response to the motion for summary judgment, but he did not file a competing statement of material facts or any evidence to support his allegations and assertions. I gave a video, but I guess and I wrote things down in some of the stuff that I was suing about, and I guess that none of that mattered. Pursuant to the Southern District of Florida Local Rule 56 1A 1A2, the district court admitted that the facts in Kukin's statement of material facts and based his ruling on those undisputed facts. Basically, I didn't argue against his facts, and I thought I did argue against his facts, but I obviously didn't. At least that's what the court's saying, and I can't argue with the court saying. All material facts in the parties' statements of material facts may be deemed admitted unless controverted by the other party's statement of material facts, provided that the court finds the material facts at issue is supported by properly cited record evidence, which that's what I'm trying to say. Any exception under this Rule 56 does not apply. The district court noted that Kunkus was dispatched following a 911 call from a citizen advising a man walking on a bridge carrying a flag and a gun. When Kunkus arrived at the bridge, he observed Taylor still walking on the bridge carrying a flag. It said, "Don't tread on me," an AR-15 rifle, a Glock pistol in his holster on his hip, a fishing pole with no bucket, bait, fishing knife, net, or other equipment commonly used by fishermen. The area was marked with no fishing signs. The governor just lifted some of the bans. Down here, like where I'm at, I am just on the north end of Palm Beach County. In Palm Beach County, Broward County, Miami-Dade County, and Monroe County, we're all under a extreme prohibition about being out in public and things of that nature. And then when the governor made fishing essential, that is when I decided to come back to Miami.
Do you know if at the time of your arrest, if fishing was permitted on the jetty in Bal Harbor?
Fishing was permitted by the governor's order.
Okay. Did you encounter the sign that's on Exhibit 8?
The day I was released.
Okay. And what did that sign say about fishing on the jetty?
It was not allowed. This is the day after I was arrested. Then I came in and saw this sign.
Okay. Well, if law enforcement officers or citizens of Bal Harbor were to testify that the sign that's on Exhibit 8 was there on the date of your arrest, you would have no basis to dispute that, would you?
Oh no, I saw it the next day.
Yeah.
I was
okay.
there. I got video of that too.
Right. In other words, you're not saying that they just went and threw that out because you got arrested. That was you understand that was there the whole time, right?
No, that sign's never been there the whole time. It only went there when COVID happened.
Right. But on the day of your arrest, it
The
was
day of my arrest, it was there.
Yeah.
But the governor's order made that sign null and void. Didn't matter. The district court acknowledged that although it was unlawful to open carry weapons, there's an exception for a person engaged in fishing, hunting, or camping, or returning therefrom. The district court concluded. Officer Kunkus had no reasonable basis to believe that the plaintiff was fishing, nor was it apparent that the plaintiff was going to or coming from a fishing expedition.
Yeah, but right now you're not coming for fishing because there's no fishing that's here.
It's going to and returning from, sir.
Yeah, but
Going to and returning
So
from.
where were you fishing from?
I was going fishing
Going where? What's
to the inlet.
There's no inlet over here.
It's over there.
You can't fish over there. It's been
I
closed.
can't fish where the people are fishing right now on that inlet.
On the other side, maybe, not on our side.
Well, guess what? I'm turning around and I'm going to go back to fishing
How
because
did you get here?
I walked.
Rather, the plaintiff was seemingly making a political statement, parading his political flag, and brandishing his fishing pole and weapons as props prior to his arrest. Plaintiff also refused to identify himself to Officer Kunkus or present his fishing license.
Well, then I'm going to walk away. No,
Why not?
because I'm not doing anything unlawful.
Well, how am I going to know that you have the right to carry these weapons if you don't have your identification?
901, 151.
I don't know what that is. Yeah, you got a hook in there. I don't know what these. Oh, battery.
Which is fine.
Yeah.
You're not coming from a hunting and fishing expedition.
Yeah, it's nothing. We have no ID on it.
Well, listen, if he's being truthful and he's coming from fishing, then he needs to have a fishing license.
He's already.
We're running the fishing license. It's a claim he's on fishing. So you know what? Fine.
Yeah,
And did you not want to tell him your name for some reason?
he had. I think I did tell him my name, but I did. They asked me for my ID, and I said I don't have to. And that's where 901.151 of the Florida statute comes into effect. What crime am I committing? And if I've committed a crime, by law, I have to produce it. Just because you have a suspicion that I might be committing a crime, unless you know I've committed a crime, about to commit a crime, or have committed that crime, I don't have to show you. That's Florida law.
Did you have your ID with you?
I did. I had driver's license, fishing license, everything. Anything and everything that could have identified me, I had. And as soon as they arrested me, I was like, yep, here you go. According to the district court, held that the fishing exception was not applicable, and held that the officer Kunkus had reasonable suspicion to detain for an investigatory stop, and also held that the officer had probable cause to arrest Taylor. Alternatively, the district court also held that Kunkus was entitled to qualified immunity, i.e. that he had at least arguable reasonable suspicion to detain Taylor an arguable probable cause to arrest him. We agree the district court that Officer Kunkis is entitled to qualified immunity for the same reasons that persuaded the district court. We agree that Officer Kunkis had at least arguable reasonable suspicion to detain Taylor for an investigatory stop. It is absolutely clear that Taylor was not fishing, and there was at least arguable reasonable suspicion that Taylor was not either coming from or going to a fishing location.
There's people fishing right now.
No, there's no one fishing right now.
Oh yeah, they are.
No, they are.
I just saw.
I was just
I
there.
came over this
Maybe
bridge.
on the other side, but not on the other side.
Well, then I'm gonna walk away.
Okay. No idea.
No,
Why not?
because I'm not doing anything unlawful.
Well, how am I going to know that you have the right to carry these weapons if you don't have your identification?
901,
You could be,
151.
I don't know what that is.
And we agree with the district court that when Taylor refused to provide his fishing license, that's Florida law.
Did you have your ID with you?
I did. I had driver's license, fishing license.
Which is fine. You're not coming from a hunting and fishing expedition.
Yeah, it's nothing. We have no ID on us.
Well, listen, if he's being truthful and he's coming from fishing, then he needs to have a fishing license.
He's already.
We're running the fishing license. We're claiming he's going fishing. So you know what?
The officer had at least arguable probable cause to arrest Taylor. We review the denial of Rule 68 for a abuse of discretion. A district court may relieve a party from final judgment where there has been a mistake. Inadvertence, surprise, or excusable neglect. The moving party must show that his mistakes or neglect would affect the outcome. The district court did not abuse its discretion in denying Taylor's post-judgment motion. We agree with the district court that Taylor did not show good reason for his failure to follow the local rules. Moreover, even if we consider Taylor's belatedly filed statement of material facts filed with his Rule 60B motion, we could not conclude that Taylor has shown a likelihood of a different outcome. Affirmed. Yeah, so basically in a nutshell, yeah, I lost this, and it really sucks because there are some things that, you know, I just don't know. You know, I tried to follow all their rules and do things in a timely manner, but, you know, most of everything that I had put down in rebutting everything that they were saying was the same arguments that I had already initially stated, you know, when they were saying, you know, in his judgment where I didn't give my fishing license.
He's already.
We're running the fishing license. We're claiming he's going fishing. So you know what?
They didn't charge me without fishing. There was no charge of me not fishing without a fishing license. And they did eventually ask for my fishing license, and they got my fishing license. And this is after they arrested me. They didn't ask for my fishing license. They wanted my ID, and I said no. I didn't have to give them my ID, which I don't. I'm not breaking the law. Under their eyes, I did break the law by saying no about my ID. And as we all know, all those charges got dismissed, or they all got dropped by the prosecutor because they didn't have enough to charge me, and they didn't have enough to obviously didn't have enough to keep it going. So this is the hard part. And for everybody that's like, oh, if you don't sue, you don't sue. Well, I'll tell you right now, I have called numerous lawyers. I've tried to do the lawyer route. It's cost anywhere from $5,000 to $7,000 to $10,000 just at the beginning. And then there's a whole lot on the backside of this. You know, you have no idea how much money is spent with a lawyer. And then when the lawyer, I've actually had lawyers tell me this, the amount of damages that you are trying to get and the amount of money that it's going to cost you to pursue this with me, you're looking at $30,000, $20,000. And I was like, and I was going to end up spending at least $25,000 to $30,000 for this lawyer. They told me it's going to probably cost anywhere from $25,000 to $30,000, and then I would be left with $20,000 from the lawsuit. And so it's not that I'm trying to. I just want this accountability. You know, at the end of the day, I still feel I won, because guess what? That deposition of him answering my questions. Do you know what 790.053 is?
No.
Do you know what 790.06 is?
No.
Is 790.053 in Florida under the Florida statute? Is that illegal in Florida?
I was wondering, can a felon carry a firearm while going fishing or hunting?
That wasn't my question.
All right. I was just wondering.
That wasn't my question. But my curiosity with this is, what legal, if you don't know, like, as you just said, you don't know the law, how can you enforce something that you don't know?
Check the form. You can answer.
You can answer.
By a careful review of the statute before taking any action.
Do you know what the Fourth Amendment is?
Yes.
What is it?
Due process.
If I was to tell you that is not correct, and I was to tell you it's unreasonable searches and seizures, allowing myself to be in possession of my personal property effects, things of that nature, if I told you that, would you believe me?
All right.
Is that a yes or is that a no?
That's an I don't know.
Journey or excursion undertaken for a specific purpose, group of persons making such a journey.
Okay. We're gonna slow this down a little bit. Was I on a journey or excursion undertaken for a specific purpose?
So your purpose was eventually to file lawsuits for monetary gain. Is that was the purpose?
That wasn't my question. My
All
question was, as a reasonable person, would definition 1, section A journey or excursion undertaken for a specific purpose?
Was the purpose
As a
for
reasonable
legal
person, would
demonstration?
that be a reasonable definition of what I was doing?
Well, there's your ostensible purpose, then there's your actual purpose.
Well, what was my actual purpose?
Lawsuit.
Do you know how many lawsuits I have?
40.
And is it lawful to possess a firearm in the state of Florida?
Yes.
Was I carrying my firearm lawfully in the state of Florida?
Yes. Although you refuse to assist me in determining that with surety.
Okay. Once again, I come back to the Fourth Amendment in 901-151. Do you believe I have civil rights?
Yes, you have civil rights.
Do you believe you violated my civil rights?
No, I don't agree.
I felt was good enough because it made me feel like he was being held accountable. Would I've loved to help put in front of a court and holding him more accountable? Absolutely. there's nothing that would have made me happier to see this go all the way to the end. But, you know, me not knowing all these rules and me not knowing, and that's not an excuse for me not knowing. That's just me, that's me saying I need to do better. You know, there were things that I didn't know and I found out, and guess what? I ended up losing. And, you know, I don't feel I lost. I mean, I lost by the court half, but at the end of the day, I didn't lose. Officer Kunkis learned something that day. I learned something about this whole process. You know, and yeah, I can only go forward from this. So, yes, I lost, but at the same time, I feel I won. So, you know the deal. Don't forget, hit that like, share, and that subscribe button, all that good stuff. I hope this was a learning process for everybody. I did my best, and that's all I can do. And I learned from it. So all I can do is move forward from it and hope that the next time, if there's a next time, which I hope there is a next time, there's a couple other people I would like to hold accountable. And we'll see if we can go those routes. And yeah. So I'm out of here. Soliaker. Deuces.